Welcome and thank you for coming today. I'm Greg Reese. I am the founder and CEO of AmeriEstate Legal Plan. Today we're going to share with you some really good information, I hope, about the importance of estate planning. We're a company that has a passion for protecting what's important to you. And today we're going to cover 4 basic subjects. A lot of people want to know, how did we get started? Why are we here? Number 2, I'm going to introduce a very important person in our company, Michelle Reese Johnson, who's the Vice President of Sales and Marketing, and she's going to really get into the nuts and bolts with you. We're going to discuss why an estate plan is valuable to own and super important for your family. And you're also going to learn today what steps are needed to put an estate plan in place. With that being said, how did we get started? Well, my background was that I grew up in a real estate household, meaning that both of my parents were real estate professionals. Shortly after high school, I actually went and got my own real estate license. As I matriculated into college, I got a job with a broker-dealer, and they put me to work in their due diligence department, ferreting out and analyzing and assessing partnership investments in real estate and oil and gas. These are offerings that a lot of financial advisors have available for their own clients to meet with their investment objectives. And so after college, I ended up going back into the family business, the real estate company, and working for the next 15 years, specializing in multifamily residential units, primarily some commercial, mini storage, and things of that nature. A couple years into my real estate career, I also wanted to get back into the financial services planning. And the main reason for that was a lot of my investment clients wanted to know what other types of investment strategies they should be thinking about to complement their real estate. And so it wasn't long before I went and got my securities licenses, my insurance licenses, and began to build a wealth management company or a practice. So for the next 15 years, I built a pretty successful wealth management firm and specializing in real estate, securities, insurance, and bringing all those strategies together to help my clients protect what's important to them. So this started way before. Come along 1998, I had the opportunity to work with a high volume estate planning firm, having learned a lot of the theory about business and estate succession planning. And I got a chance to work and became like the chief paralegal for a high functioning estate planning firm. So I learned all of the back office aspects and criterias and counseling with clients and drafting documents, the whole 9 yards. And I decided ultimately that there had to be a better way, because most estate planning at that time was really only accessible to the wealthy, and most folks in the middle class didn't have good access to that. They were unsure of the cost, afraid of how to find a good attorney, etc. And so I came up with an idea to create a legal plan to bring more professionals into the mix to try to deliver consistent, high quality, professionally guided and driven estate planning services to people that were generally underserved, in my opinion, at that time. And so that's where AmeriEstate was born, again, back in 1998. And since then, we've served over 40,000 clients, mostly specializing in their estate planning, asset protection planning, forming corporations and LLCs for them to help them get their own private businesses started, much like I had done earlier in my career, and also focusing on elder law and public benefits planning, to help protect the seniors in our population that either need financial assistance with care or protection from the unscrupulous people that like to prey on seniors. So that was kind of the core specialties that founded AmeriEstate, and we really have not deviated from those principles and those core specialties. So it's not just one of the things we do, it's the only thing we do. So today and next, I want to introduce you to, as I said, a very special person, Michelle Reese Johnson. She's my sister. She's been my Vice President of Sales and Marketing for almost 20 years now and does a fantastic job. So Michelle is going to introduce the concept of estate planning to you, some of the nuts and bolts, reiterate why it's important to own, and also talk about the steps that you would follow in order to get your estate plan in place. So without further ado, let me introduce to you my sister, Michelle Reese Johnson. Thank you so much.
Hi, I'm Michelle Reese Johnson, Vice President of Sales and Marketing with AmeriEstate Legal Plan. I have so much to tell you in such little time. But first, I want to share with you a little bit about my background and how I came to AmeriEstate over 22 years ago. You see, right out of college, I knew I wanted to help people, and I also needed to make money. So I decided to step into the real estate business because I kind of grew up with it. My family was in real estate and it was familiar to me. It was very exciting, and I was happy to help people buy and sell their dream homes and their investment properties. It was a very exciting time for me. The one question I always had was, Michelle, how should I take title to my house? And I'd say, well, you know, most people do husband and wife as joint tenants, or husband and wife as community property, or sometimes if you're buying with your brother, you would be tenants in common, or sometimes you would just take it as a single person. That's all we knew. Nobody knew anything else back then. Well, I sure wish I would have known back then what I know today, or what I learned 23 years ago. And now that has become my passion to help others take title the right way to their home and all the other assets that are important to them. What is an estate plan? Well, an estate plan is not defined by the value of what you have. It's more of the collection of items and things that you have. Now, there are 3 ways to manage your estate. The first way is called the do-nothing plan. The second way is just the last will and testament plan. And the third way is the living trust way. I'm going to talk about the first way, the do-nothing plan. We all know what that is, right? Do I need to explain it more? We just do nothing. We just live our lives and we continue on. And then eventually we're all going to leave this blue marble and we're no longer going to be here. So if you did nothing, the state that you live in has a plan for you. They've got it all figured out how your estate is going to be distributed and who's going to get your assets, because frankly, you didn't do anything about it while you could. So trust me, the state's plan is not the plan you want. And it probably is the worst thing you could ever do to your family. By the way, if you pass away without a plan, it's called dying intestate, because you're not here to tell anybody what you wanted, so the courts have to figure it out. And guess what? That takes about 18 months to 3 years to figure it out. So most likely you don't want to have that happen, but I would say this is the most common plan. The second most common way that most people take care of their estate plan is called a last will and testament. Let's talk about a last will and testament. I always tell people, well, good for you. You set it up. At least you put something in place. So when you pass away, at least the courts know who you want to get your stuff. And also the last will and testament handles your guardianships for the minor children. I applaud you for at least doing something, because most of the time when clients come to us, they have nothing in place at all in their 50s, 60s, 70s, and 80s. But let's talk a little bit about this last will and testament plan. Number 1, it's only good while you're gone. It doesn't do anything for you while you're alive. Number 2, I call it the 3-ring circus. You know why? Because let's face it, if we're going to go to a circus, we have to first buy tickets, right? So that's the first thing. We're going to buy our ticket to the circus. Well, you can buy your ticket to probate. For instance, in the back of the papers, have you ever seen those advertisements that say the estate of Ruth Clark? And there's a number there. You could go and check out what Ruth had when she passed away. So that is the ticket or the advertisement. So you're going to go ahead and look at the paper, get your advertisement, buy your ticket to the probate, and then guess what? You're going to show up to the probate. You don't know who Ruth is, but you know Ruth has a lot of good stuff. And you're going to claim that you knew Ruth, you were her gardener, or maybe she was your best friend, but nobody knows this. You know, so Ruth is no longer here to tell anybody that she has no idea who you are. So this is why we call it the 3-ring circus, because people show up out of the woodwork to find out about what's in your estate, and they want a piece of it. So a last will and testament may at least tell the courts who you want to get your items, but it still becomes a public notification process. So people will still come out of the woodwork and claim they might have some interest in your affairs. So this is the last thing we want to do. Nobody wants their affairs to be public, but with a last will and testament or without one, your affairs will be public and everybody can see what you had when you passed away. I want to share with you a true story that happened about 20 years ago when I first started with the AmeriEstate Legal Plan. You see, there was this gal named Joey. She came running into the office, literally knocking on the door saying, "My name is Joey and I want to set up my estate plan." We're like, okay. I found out a little bit later why Joey was so adamant about setting up her estate plan. Now, she is a single gal, but she said, you know, I just got my inheritance check from my mother's estate that took 18 months because she did not set up a living trust. And the first thing I want to do is set mine up because I don't want anybody, my sisters and my family, to go through what I personally went through with my mother's estate. My mother, she said, would not set up a living trust. I begged her to do it, but she told me, everything's okay, honey, I've got it all figured out. My attorney said I don't need a trust. I need a last will and testament. Everything's going to go to you and your sisters, and it'll be fine, honey. It wasn't fine. You see, Joey had to live with her mom for 2 years because her mom went downhill and had to be taken care of 24/7. Joey had to quit her job. She had no income coming in. Mom passes away and the estate is frozen. Joey cannot sell the house, cannot get access to mom's small bank accounts, and cannot do anything without a court telling her what to do. It was a shame. And it was really sad. And Joey suffered from that. So 18 months later, she came into AmeriEstate Legal Plan, set up her living trust, and guess what? I hired her to help me. The third way, and the best way to set up your estate plan, is setting up a revocable living trust. A revocable living trust is like a safe to protect your assets from probate, estate taxes, and incapacity. So for instance, it's kind of like a corporation that you're going to set up. So you are the owner of the corporation and the manager of the corporation. Well, you're going to do the same thing with the trust. You're going to set up a trust and you're going to be the trustor or the owner or the creator of this document. And you're also going to be the trustee, which is the manager of the document. So you own it and you control it. Your life does not change at all. You continue on the way you are, but the important thing to know is you have to have this safe and you have to have it structured. So if something happens to you, not only when you're gone, but while you're alive, this safe is going to protect you from things like probate. It's going to make sure that your assets get to who you want them to go to. It's going to make sure that if you become incapacitated, we're going to have the proper documents in there. For instance, a power of attorney for healthcare and a power of attorney for asset management. The two other most important documents that any adult should have are those two. It's also going to name guardians for your children. You're also going to decide on your vice president of this corporation. It's like we call it a successor trustee when you have a trust. The successor trustee is going to step up when you can no longer handle your affairs, and they're going to take over like nothing happened. It's either if you become incapacitated or when you pass away. It's a simple process. There are no court involvements. There's no public notifications. There's no attorneys involved. Guess who's involved? The people who you choose to take over your affairs. So a living trust is not only a document when you pass away, it's an important document while you're here living your life. Any of us can get in an accident. Anything can happen, especially these days, right? It's so important to know that estate planning is not just for the rich and famous, it's for you and me, middle America. We have more to lose than those rich people. So take heed and really make a plan to get yourself educated. And I hope I've helped you a little bit here, understanding a little bit about a living trust. But just know that living trusts are going to go with you during your lifetime and beyond. The reason being is living trusts never die. The courts can only probate a person who is no longer living. That's what probate's about. Living trusts, I like to say, live on after you're gone. It continues. There's no hiccups. Your children are taken care of. The houses can be sold or passed on. The financial accounts with the death certificate is all you need. Immediate access. There's no question about it. It is the best thing you can do for yourself and your family. So, who needs a revocable living trust? Well, if you're watching this video right now, probably you need one. And the reason why I say that is you're taking the time to get yourself educated because you've heard something about living trust, but you're not quite sure if it fits in your life or your family or your needs. But let me just go through a quick round of ideas to think about for people who need or should consider setting up a revocable living trust. Number one, if you own property, any kind of property, land, commercial buildings, your home, your lake house. If you have minor children cannot take title to assets. So if something happens to you, a trust will manage that for them until they become of age. If you have a special needs child, please take heed and set up a trust for yourself so your children, those special needs children, can be taken care of. If you have financial accounts are sitting in a bank with just your name on them. If you pass away or become incapacitated, they're shut down. Nobody can help, nobody can pay your bills, nobody can get to your assets because the courts have to step in and manage that because a trust is not wrapped around those documents or those financial accounts. What about pets? So many of us love our pets. You need to put special instructions on who's going to take your pet. Or what about maybe you're a single person, but you have a home and you have some things to give and you care about some charities that you're very passionate about. Well, rather than leaving it to the state and the sister that you don't like anymore or that mean, cousin that's going to come after your things, give it to your favorite charity. God, that would make the world a lot better. So how can you get an estate plan for yourself? Well, remember we talked about the 3 ways to manage your estate? Well, there's also 3 ways to set up an estate. And the first way is called the do-it-yourself way. We all know what that means, right? We all love do-it-yourself. I love do-it-yourself. I love crafts and all kinds of things to do it yourself. But the do-it-yourself plan has a lot of holes in it that you aren't even aware of what can happen. I know, I see it because I see the process when people pass away and when they have a living trust and not a do-it-yourself, things go very smoothly. I have also seen the do-it-yourself way. And a couple examples of that is people actually go to the stationery store and pick up their documents and fill them out. They also go online. There's tons of online opportunities right now, right? We all love to go online. We're all looking for a good deal. We all want to save that extra buck. I do too. I always want to. But not when it comes to the most important thing in my life, my family and the assets I have worked so hard for over the years. Now, I'm a middle America person. I'm not wealthy, but I have more to lose than anybody else. The wealthy people have the money to take care of things. I don't have that kind of money to waste. I don't have $30,000 to $100,000 to give to the courts. I need that for my child and my husband. So, and also with that do-it-yourself online format, it's a very popular format for attorneys because they love it when somebody does a do-it-yourself plan and they pass away because that's big business for attorneys because nobody knew what to do with the do-it-yourself. They didn't put anything in it, they didn't tie their house in it, they didn't change their bank accounts. They didn't even sign it half the time. They just got something in the mail that said, here's your instructions how to fill it out. Do it yourself. Guess what? They never do it. It's not complete. It was a waste of money. Another do-it-yourself is, I call it the Band-Aid approach. I see this so much. I see people putting a child on title to their home, their financial accounts, maybe their car, things like that, because their husband might have passed and they're left by themselves on title to their assets. And they think, well, I'm going to put Junior on title with me because if I die, he'll make sure that everybody in all the other kids, the 5 other kids, the siblings, will get their share of everything. I trust Junior. And so he'll do the right thing. Well, we kind of see where that story's going, right? We hope that Junior would do the right thing, and it's always the best intention for our clients. It's always a good intention that they're just trying to save everybody the headache. But what happens is when Mom dies, Junior can say, sorry, Mom gave me the house and the bank accounts, guys. That's just the way it is. I'm sorry, she wanted me to have it. Oh, well, and he just goes on with his life and everybody else, and it just tears the family apart. The other thing I see when you put a child on title to your assets, like your home and your bank accounts, if that child gets in a car accident, or that adult child, or if he gets sued, or if he's going through a bad divorce, guess what? They're looking for assets that Junior's entitled to, and guess what? He's entitled to all your stuff. They're going to come after your assets, and that wasn't the intention, right? Yeah, so what about when Junior wants to, or when you want to sell your house because you're going to move to Florida and retire on the beach, right? Well, Junior's not ready. He's not going to, no, he doesn't want you to sell the house because he's planning on living in that house. Well, he's entitled to that house with you. You can't move to Florida. He's not going to sign the deed to sell your house. You're stuck. So that is not a good idea to put other people entitled to your assets with you. The better plan is to put them into a revocable living trust. Your kids, your family, everybody will get your assets the way you plan it, and you're in control while you're alive of your whole estate. The second way you can set up your estate plan is to call an attorney. Now, most attorneys charge a lot of money to set up estate plans. The reason being is they have to. Their time is worth a lot. It's anywhere from $350 to $650 an hour right now. And it takes about 11 hours to set up an estate plan with an attorney. We know this because we've figured that part out. So you're going to spend anywhere from $2,500 to $6,500 to set up an estate plan when you call an attorney and go into their high-rise building and sit in their big leather chair and sit down and have a face-to-face. And you know what? That's okay. At least you're getting your estate plan done. Excellent. I commend you for doing that. Matter of fact, I have a story to share with you about this exact thing. About 8 months ago, we hired a new gal to come work with AmeriEstate. She's in charge of our marketing. And right before she came to AmeriEstate, she said, I wish I would have known about AmeriEstate. I just set up my living trust. Right before I came here, I said, well, congratulations, good for you. I'm proud of you. Most people don't even do that. And she said, yeah, we feel really good about it, and thank God, but I said, well, how much did you pay for that estate plan? She said, $6,500. I'm like, wow, okay, great, congratulations. Good for you. You know, when she came to AmeriEstate, she realized what a great value we were, and she wished she would have known about us. But it's all said and done. She feels good about it. I'm happy for her. It's the best thing she could have done for her family and her husband and her minor children. So come Christmas time, she calls me up and she says, Michelle, guess what? I said, what? She said, I got a box of chocolates from my attorney for Christmas. I said, you did? I said, well, how were those chocolates? She said, they were delicious. I said, were they worth $6,500? And she just laughed. She said, no way. But they were good. I said, well, hey, it's okay. You got your estate plan in place, but just know that you are going to pay a lot more when you go directly to an attorney. because they work by the hour, and that's about what it takes. So, and the third way to set up your estate plan is through AmeriEstate Legal Plan, and I'll tell you a little bit more about that. AmeriEstate works in a hybrid approach. We have a team of experts that come together. We have attorneys in 6 states we're in. So what that means is, when you come to AmeriEstate, you're going to speak to one of our attorneys, and that consultation is going to be done over the phone. Now, some people, they're not okay with that, and that's fine, because we're not for everybody, but we are for the majority of people. And basically, with COVID and the times that we've gone through this past year, our process has just been phenomenal for everybody who it's come to their attention that they better get their estate plan in place. So AmeriEstate takes care of the initial consultation through one of our expert advisors. They're going to help gather the information for you and get it all down on paper, give you some ideas of what to think about. And they're going to get that over to the attorney, who's then going to talk to you about your estate plan. And once that's all done, the estate plan is going to be drafted, and we're going to get that set up and delivered through one of our expert notaries who's done many estate plans for us. It doesn't matter where you live in the states we are in. We're going to get that funded, delivered, and notarized for you. So AmeriEstate, the reason why we work the way we do is we can bring the costs down to you as the consumer, because we're not taking 10 hours of the attorney's time. We're doing a lot of the busy work, and we're giving it to the attorney to talk to you about your legal consultation. And that's what he's focused on. And then he gives it back to us to create the document under his supervision. And then we also have our notaries who are going to help out and come to your home to deliver it. So everything is complete. And also, what's good to know about AmeriEstate is it's so easy for you to make updates and changes to your trust. It's so affordable. As part of a legal plan, it's only $150 a year, and it's not mandatory, but that enables you to always have access to us for phone calls. You need a change to your trust. You have an issue. You need an attorney referral for another matter. That's how we're structured, because we want to make it affordable for you to get the help you need after your trust is set up and you want to make changes. So we're here for you 7 days a week, every day. And guess what? If one of our attorneys retires, or maybe they're not going to do this anymore, maybe they pass away, we're going to send you to another one of our attorneys. If you go to the high-priced lawyer, they pass away, their practice goes away. You have nowhere to go anymore. So we can keep this going perpetual, and then we're here for your family. When something happens to you, you become incapacitated, or when you pass away, guess what? Your family members call us. We're going to help them walk through the process. It's not going to cost them a lot of money. We've got everything on file, and they can settle your estate within 30 days as long as they have a death certificate. It's a really good system that we have in place, and it has been working beautifully for 23 years. We have so many referrals. We have advisors calling us across the country. How can they get an AmeriEstate trust for their clients? So I just want to let you know that we are tested over 23 years of bringing superior service, customer quality documents, and phenomenal expertise to you in every step of an estate planning process, whether it's when you start it, when you pass away, your kids need to inherit, or maybe you need to do some other services that we have, like a corporation or an LLC. But this subject is just about an estate plan today, and I hope you've learned a lot from me, and that you take this to heart, and you set up your estate plan. Hopefully you'll choose AmeriEstate, but if you don't, get it done the right way, not the do-it-yourself way, and not the do-nothing way. Thank you for taking the time to listen to me today about the importance of setting up your estate plan. I'd like to now turn it back over to my brother, Greg.
Okay, thank you, Michelle. That was a great job. Listen, for you folks watching today, We'd love to extend a special offer for you, $200 discount plus 2 years free in our legal plan, which provides free simple changes and amendments and so much more, and a value of $500 for that service. All of our services are done at a flat fixed fee as opposed to hourly rates that most attorneys charge. This is so that you get better value, more bang for your buck when you approach the types of services we have, and we will always quote them in advance so there's no hidden fees or surprises for you. So again, hopefully you understand why this is so important, and I would encourage you, if you'd like to learn how easy it is for you to get started today, please schedule your free consultation. And thank you again for joining us. Bye for now.